This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address, and this is Ask a Lawyer, March 27th, 2020. In the midst of the coronavirus, the world is upside down, and it seems to affect every single aspect of society, even those we would never expect. So, a couple weeks ago, we were speaking about litigation that had already started in connection with the virus, and litigation that conceivably could be expected. So I thought today we would start talking about fertility.
Excuse me?
Well, how the coronavirus is a fertile area for litigation.
Okay.
Ha, ha.
Yeah, okay. I thought you were talking about the corona babies in 9 months.
Oh, goodness, no. There may be some of those, but I don't know if you can sue anybody for them. There is no such claim for wrongful life. That's already been litigated.
Oh, my.
Anyway, welcome to those of you listening on WPSL. Welcome also to those of you who are relatively new listening on WSTU. And if you're listening on the web, welcome to you as well. Maybe one of you is in Alaska or Timbuktu.
Guam or someplace like that.
Yeah, maybe one of you somewhere in the world that, is so remote that it's safe. If so, give us a call because I'd like to go there, if anybody would fly me there. All right, so we had started discussing a couple weeks ago the potential for lawsuits by employees for failure to protect them from the coronavirus.
Ooh.
We talked about the possibility of workers' compensation actions if you were actually contracted the illness while at work. We talked about invasion of privacy, discrimination, unfair labor practices, negligence claims, all of these sort of coming out of the tort area of negligence and concept of failure to warn.
It's interesting. One of our former interns in San Diego centuries ago is with CBS News. And they've had to close CBS New York because of the coronavirus. And one of their hosts is being replaced because she's been quarantined, Jane Pauley. But, what the technical union has said is they have asked for protective gear from CBS management, who has turned them down.
Ah, yes, and that is happening everywhere.
Really?
That is happening everywhere.
Oh, my.
And in fact, we're going to talk about a lawsuit coming up of just that concept.
Oh, no.
And folks, that was not planned. Greg doesn't know what I'm about to talk about, so he just came up with that on his own. All right, so what about if you are getting inadequate protection at work from the coronavirus? What if you're a nurse at a hospital and you complain that instead of the hospital distributing N95 masks, which even I've learned what they are, effective at preventing the wearer from contracting the virus, what if the hospital is providing staff with less effective masks? What if it's providing staff with masks to be reused? We've heard about that a lot on the news.
Oh, yeah, that's been a big news story last couple of days.
What if they're running out of even those and you're using kerchiefs or bandanas or whatever you want to call them? What if that's all they have? Well, a nurse at a Northwestern hospital has filed a lawsuit alleging that she was fired after warning coworkers that the masks that the hospital was providing did not adequately protect them against COVID-19.
Oh, boy.
And she alleged in her lawsuit that instead of distributing the N95 masks, the hospital was providing something much less effective. She actually sent an email to co-employees on the hospital system, as well as supervisors, that the N95 masks were more effective than what was being distributed by the hospital, and the next day she was fired. She has now filed a lawsuit. She claims that she was laid off in retaliation for warning the staff that the mask the hospital provided was unsafe. What is going to happen in that lawsuit? Well, that is really an interesting question.
Wow.
Because there is no clear-cut answer. Remember, virtually everywhere in this country, you're an at-will employee. And although other states modify the pure at-will doctrine, unlike Florida, and the at-will doctrine is essentially, and some people call it right to work, and that's really meant for unions. It's at-will.
We were a closed state in California.
And that's a union concept.
Okay, yeah. Well, it was.
But in terms of every worker, this is mostly, there may be 2 states left now that are right-to-work states, not in the union context, but in the concept that an employer can only terminate you for cause. Everywhere else, you're an at-will employee. Now, in the purest form of at-will, which is Florida, your employer can fire you for no reason at all, a good reason, a bad reason, a fair reason, an unfair reason, a factually correct or incorrect reason. For example, the one I like to use is cashier calls me. She's terminated because her drawer was $10 short. Later that night, they find the $10. It was a mistake. She wants to know, can she get her job back? No, not unless the employer wants to give it to you. They were wrong. Tough luck. You're an at-will employee. That's harsh, but that's the at-will employment doctrine.
I would think the employer would use common sense and just
You would think, and many do, but many don't. Now, in the purest at-will employment, the only thing you're really protected against is a violation of state or federal law. So, the ones I most commonly see. Title VII of the Civil Rights Act, which protects you against discrimination and sexual harassment, disability, discrimination, age, race, national origin, gender, things of that nature, protected classifications. And the same is true for the Florida Civil Rights Act. I see suits where you file a worker compensation claim and you're retaliated against. I see whistleblower actions where you complain about an unlawful policy or practice and you're fired, demoted, salary slashed, hours cut, things like that. But those are where you have protections under state or federal law. If you don't, then tough luck. The courts actually have a phrase for that type of a situation. It's called bad boss syndrome. And the courts have said...
Are you serious?
Oh, absolutely. The courts have said the law does not protect you against having a bad boss. That's just tough luck. So, in this lawsuit where the nurse is suing because she was fired for complaining about the inadequacy of the masks. Now, she's not complaining about something that violates the law. So she's not protected as a whistleblower. I don't see on the face of it any protection.
Wait a minute, the disease could theoretically kill the healthcare workers.
That's right.
And that's not a violation?
Well, that's what we're going to talk about a little bit. Because I have actually begun getting phone calls. It started. I've had a few calls already about people who either have been terminated or are afraid of going to work for fear of contracting the virus and want to know, can I stay home and can my employer fire me? And those are very difficult questions to answer right now because there is no real law on it. So what does a good lawyer do? You look at the law that exists, you try to analogize it to the existing situation, and try to project as to what would a likely outcome be. Now, that may not help somebody who's asking for advice as to, should I go to work, can I be fired? But if you've already been fired, that certainly is a potential area for a cause of action, or at least a demand letter.
But wouldn't a judge use common sense and
Common sense in the law? No, the law is decided based upon the law, not common sense.
Okay.
Hopefully they coexist, but very often they don't coexist. For example, a trial is not necessarily the search for truth. It is the search for truth based upon admissible evidence, which is evidence that can be admitted based upon the rules of evidence. Sometimes relevant evidence is excluded. So it's not purely a search for truth.
Technicalities.
Well, that's true. So let's look at this situation and try to analyze it. I was sitting at home, quarantined, earlier in the week.
You and the rest of the world. Yep.
And I started to think about this idea. I did a little bit of research and didn't find anything, certainly not any decided cases. So I started thinking about a couple statutes that I thought might have applicability and running into roadblocks as I did the research. And research leads you down another branch and then a different branch, and you keep on going until hopefully you find a theory that might actually work. So the first thing I thought about was OSHA, the Occupational Safety and Health Administration Act. OSHA is applicable to all employers. OSHA has tons of regulations as to what is a safe and unsafe workplace. And wouldn't it be an unsafe workplace if you had a reasonable fear of contracting the illness, particularly if you had some susceptibility, if you had what they call a comorbidity, diabetes like I have, or if you were above age 65, the target audience for this virus, unfortunately.
Or if you had chemo.
Precisely. A woman who called me had radiation and was concerned about going into work. So I started researching OSHA, and I have to admit I learned something I did not know. You can't sue under OSHA. There is no private cause of action.
Why do they exist?
That's a really good question. You can file an administrative complaint, and OSHA will investigate and theoretically might take action against the employer. Now, the same thing exists, by the way, under HIPAA. There is no private cause of action to sue for a HIPAA violation. I've always thought that was absolutely absurd. I don't know why Congress passed that statute without a private cause of action. But all you can do is file an administrative complaint, and it will be investigated. You don't get anything out of it, but the employer might be slapped a little bit.
And you'll get an answer 20 years down the line.
Perhaps. So if you're not really protected under HIPAA, and if you're not really protected under OSHA, what good are they? Right, that's really what I thought.
Exactly.
So I was researching, and I came across a theory which I was led to by looking at the OSHA question. And that was the Americans with Disabilities Act. Now, how does this impact the Americans with Disabilities Act? A disability can be something as simple as an allergic reaction to a fragrance. If you have a sensitivity to a fragrance, and you alert your employer, the employer's duty is to have an interactive communication with you to try to reach a reasonable accommodation. If a reasonable accommodation can be reached, even if it's not the one you want, then the employer has done its job. If there is no possible reasonable accommodation, which sometimes exists depending upon the size of the employer or the type of job you have, then the employer doesn't have a duty to do anything for you. But now let's look at it in this context. You have a concern about going into your job site because you're required to be close to other employees, can't be separated. Maybe you're required to be close to the consuming public. You've had chemotherapy or radiation, or you have an autoimmune disorder, or you're over 65, or you have diabetes, or whatever else.
Which is a good part of the population.
Right.
With
that
something.
Can be viewed under the ADA as a disability. So if you then ask your employer to make a reasonable accommodation, the employer has a duty to have an interactive communication with you as to what would be necessary to reasonably deal with the disability, accommodate it. Now, sometimes, that could be putting you in a fragrance-free location, but let's deal with the virus. Maybe it's putting you in a section of the workplace where you can be separate, your own office, let's say, from other employees or from the public. If that's possible, that could be a reasonable accommodation. Maybe it's putting you on a different shift where you're going to have minimal interaction with human beings. That could be a reasonable accommodation. Maybe it's permitting you to work from home. If that does not place an undue burden on the employer, that can be a reasonable accommodation. So what happens if a reasonable accommodation is available and the employer does not want to accommodate you? Or worse, what happens if you ask for a reasonable accommodation and you're fired? Now we get into the issue of, would the ADA protect you in terms of filing a viable lawsuit on which you might be able to prevail as a result of the coronavirus? Now, again, there is no law yet on this. But looking at what the ADA is designed for, looking at what types of things have been classified as disabilities, I think it is a fertile area for potential litigation.
So unlike OSHA, they've got some teeth?
Under the ADA, yes, you can sue. Now, the ADA is part of Title VII of the Civil Rights Act, which means there have to be 15 employees or more. You're not protected if your company has less than 15 employees. I've often told my paralegals I'm free to sexually harass them because they can't sue me. My girlfriend is staring at me right now. Apparently she's never heard this. But yes, I have jokingly told my prior and existing paralegal I'm free to sexually harass them. And I've explained that in the context of explaining Title VII of the Civil Rights Act.
Your friend just left the studio screaming.
Now, of course, we're going to deviate for a moment. If I were to lay my hands on anybody, that's a battery claim. That's a civil tort battery. If I was to threaten somebody with an offensive touching, that's an assault. But it is not sexual harassment under Title VII of the Civil Rights Act or the Florida Civil Rights Act because there aren't 15 employees. Anyway, that's just a little deviation here.
Yet another technicality.
Well, all these statutes have numbers. The Family and Medical Leave Act, 50 employees within a 75-mile radius of where you work. They all have different numbers, And even in the current stimulus package, they were debating over what number of employees are necessary before the employer can get money or before the employer can buy back their own stock. They were debating number of employees. This is what Congress does. And, there are lots of reasons they come up with different numbers. But anyway, for the ADA, it is 15. So let's assume there are 15 employees, and let's assume you have a situation where you have a reasonable fear of imminent personal injury or death, and you ask for a reasonable accommodation. I would argue that the employer has a duty under the Americans with Disabilities Act to find a reasonable accommodation if one exists. Now, if it doesn't exist because you have the type of position where maybe you're the only one in that position and they can't go without that position, and if you leave, even let's say they give you a month leave and they have to hire somebody else, there's nothing that says they got to fire that somebody else when you're able to come back. That may not be a reasonable accommodation. Now, if it's a type of situation where you can effectively work from home, I would argue the employer has a duty under the current pandemic to allow you to work from home. I think that utilizing the legal anchor of the ADA, you would be able to make a wonderfully emotional appeal to a jury when it comes to trial.
Okay, again, I have to ask, how long would it take to get to trial?
Well, as with any case, depending upon state or federal court, 2 years or so. That's just the way it is. Can't get around that. Now, could you seek a temporary injunction requiring the employer to keep you employed pending the outcome of the litigation? That's much more difficult, a much higher hurdle to face. It's not necessarily impossible in the right set of circumstances. Not every employee is going to be able to seek a preliminary injunction.
Okay, courthouses are shut down now. How do you seek an injunction if there's nobody there?
Courthouses are open for emergencies. They are always open for emergencies.
Oh,
there is always an emergency duty judge assigned. Now, would this qualify as that type of emergency? Probably not.
In a pandemic.
If you are being beaten by your spouse and need emergency relief, you're going to get into court. Okay? Emergencies are going to be classified and defined very narrowly, and even more narrowly depending upon the situation. An employee's individual rights to a job, even as a plaintiff's employee attorney, I don't think would qualify in most cases as that type of an emergency, which would require the attention of an emergency duty judge. Because for now, the courthouses are closed to in-person hearings. You can have telephone hearings, but you really can't have a telephone evidentiary hearing, which is what's necessary for injunctive relief. Because you can't swear in witnesses remotely. Well, you can technically.
Oh, FaceTime? Skype?
Well, there is there's an executive order in Florida that you can administer an oath remotely during the period of the pandemic. But for purposes of an actual courtroom, I don't think most judges would permit it, because an essential part of determining who prevails is being able to evaluate the credibility of witnesses. That means having the witnesses in front of you, being able to not only hear what they say, but see how they say it, how their mannerisms are they giving indicators of lying?
But you can do that on Skype.
I don't know that most courts are set for, 5 or 6 people appearing by video and everything being effective in terms of bandwidth.
Okay,
I don't
there
think
you go.
that's
The technical aspect of
So,
it. Yeah.
if we have an emergency, a true emergency, I think anybody can probably get access to the court. A true emergency. But the average individual employee, I don't think that's going to happen, honestly. You can still file suit because everything is filed electronically. I still have access to the Florida e-portal. I can file suit, I can file motions, I can file discovery requests, I can do deposition notices, I can even do depositions remotely now that you can administer an oath remotely. All of that can be done. What I can't do is effectively get into court for a hearing, except perhaps a telephone hearing, and given the volume of people who are going to be seeking telephone hearings, unless my hearing is really important, not a motion to compel discovery or for extension of time, unless it's really important, I'm probably not even going to get a telephone hearing. And that's the reality during the pandemic. But in terms of legal rights, I think the ADA is a potentially fertile area for litigation, and I would dare guarantee that we're going to see law created out of the coronavirus under the ADA and under perhaps other statutes. We do have George on line 1. Hello, George. How can I help you? George, you there?
Hello, George.
Dear George, going once, going twice. George, if you got disconnected, feel free to call back and we'll be happy to talk to you. Anyway.
He was shy.
Oh.
He was shy, but he wanted to know, can you be evicted during this time? And I told him there are probably some follow-up questions to that, but he wants to listen.
There is
Okay.
I believe, I don't know for sure in Florida whether Governor DeSantis has issued an executive order in this regard. Somebody listening may know, and give us a call at 340-1590. I could probably Google it in seconds, but I can't do that while I'm on the air. I do know that many states, many cities across the country, executive orders have been issued staying evictions for 30 days, 60 days, what have you. It's different depending upon the executive order. I do not.
You've got car companies delaying car payments.
Right,
So
and mortgage forgiveness.
yeah.
I do not know offhand whether Governor DeSantis has issued an executive order that stays eviction proceedings for any period of time. I would hope that the governor has done so. Certainly believe it's reasonable to have done so. I do know this, though. And this is where you get into the difference between law and practicality sometimes. I have heard that there are innumerable police departments and sheriff's offices in Florida that are refusing to process eviction orders for a period of time. Now, that might sound like the police refusing to obey the law. Isn't that interesting? In this case, I would probably applaud them. But it is really a matter of law enforcement discretion as to where they put their resources. And if they decide that their resources are not best appropriated to processing evictions, then they're actually immune from suit for that. They have qualified immunity. Police departments make decisions every day about how to allocate resources, putting more police in one neighborhood than another neighborhood, utilizing DUI checkpoints, not pulling over people who are speeding under 50 miles an hour over the speed limit. Every day they're making decisions about how to allocate resources. So if they've decided not to process eviction orders from the court, then they're going to not process eviction orders from the court. And I do know that many sheriff's departments and police departments within Florida have indicated that they're not processing evictions. I hope that helps, George. I know it doesn't specifically answer the question completely, but I hope it gives you a little bit of guidance.
Now, if he got a hold of the sheriff's office, would that help?
Sure. If he got a hold of the sheriff's office
Because they have a general information.
and asked, "Are you processing eviction orders?" and if not, for how long have you decided to hold off? I'm sure you would get an answer. You might also, honestly Google, eviction orders, Florida executive order, and see what comes up. That should probably get you very quickly on the first page of the Google results to an answer as to whether the governor has issued an executive order delaying evictions for a period of time. Frankly, that's the first thing I do as a lawyer before I go into legal resource software like Lexis or Westlaw. First, I use good old Google, see what they can tell me.
So Westlaw is still around?
Yes, it is.
Gosh. I used that in college in the 60s. Oh, my God.
Now, interesting story, Lexus. Lexus was sued by the Lexus automobile company.
No way. Really?
Yes, it was. Way back before I even moved to Florida, way back in the early 1990s. Lexus, the automobile company, no, I'm sorry, it's the other way around. Lexus, the legal research company, sued Lexus, the automobile company, claiming trade name infringement, that Lexus, even though it was spelled with a U, not an I, sounded too similar and would likely cause customer confusion.
Well, that got tossed out of court, I'll bet.
Well, it didn't get tossed out, but Lexus lost. Likelihood of confusion is the epitome of a trade name infringement action. And the court determined that because Lexus was a legal research company and Lexus was an automobile sales company, that their markets of consumers were completely different and that there was no likelihood of confusion. Therefore, Lexus and Lexus continue to exist. Now, I had reason to be watching a TV show where I saw a good old-fashioned automobile gas station sign for Esso, E-S-S-O. And what many probably don't know is why Esso doesn't exist anymore, and does Esso exist in some incarnation? Well,
it's a British company, right?
No, it's not.
Really?
Esso was sued by Standard Oil in California. Standard Oil's initials are S-O. Standard Oil existed long before the gas station known as Esso. Standard Oil is also in the oil business. Standard Oil, with all its money, won a lawsuit against Esso. Esso had to change its name. Esso decided to take the S's and turn them into a different consonant and add another consonant to the end of the word, and we now know it as Exxon.
Really?
When I was a kid,
Oh, my goodness.
when I was a kid visiting my grandmother in Montreal, in Canada, Esso station still existed. Initially, Esso changed their name to Exxon only in the United States, because that's where it was required. But the Exxon name soon garnered that same trade name value, so that Exxon changed over all of its fuel stations worldwide from Esso to Exxon. So you won't see an Esso station unless it's on a TV show that is set back in the 1940s or 50s.
Wow, that's amazing.
Not exactly our coronavirus topic, but, interesting tidbits anyway. So, to sort of, sum up for now, on the coronavirus, there are no guarantees here. It is a new area of law, hopefully one that will be short-lived. Litigation will go on for a decade, I guarantee you. But hopefully the necessity for this particular type of protection will be short-lived. But there are going to be employees calling lawyers all over the place about different variations of I was fired, or I didn't want to go in, I was afraid. And then, it becomes a screening process. Why were you afraid? Generically, just because of the crisis? That's probably not good enough. Because you're 72 years old? That may be good enough. Because you're 72 with emphysema, diabetes, and previously had cancer? That's a heck of a lot better. Now, lawyers look for the best cases when they're testing novel theories of law. Because we know that whether we win or lose at the trial level court, there's probably going to be an appeal. And it may wind its way to federal circuit court. It may eventually wind its way to the U.S. Supreme Court. But you always want the best factual scenario to argue for an extension of law or creation of new law. And so somebody, being quite frank here, who calls my office with I was fired, but I'm not sure I can tie it to the virus. I was written up once 3 months ago. That's not the case I'm going to test it on. I did have somebody call me who said that their employer was a coronavirus denier, that this was no big deal, it was a hoax. Man, that would be a great case
to
argue
Fox.
in front of a jury. The problem was this particular prospective client had no change in her work environment, so there was nothing different than before, 3 weeks ago during the coronavirus, and so it didn't seem to me to be the case either to make the challenge. We do have Elizabeth on line one wanting to ask a question about loan forgiveness. Hello, Elizabeth. How can I help you?
Hi. I just had a quick comment. I've seen ads on TV. Someone mentioned on the radio a while ago that some of the car companies are allowing loan forgiveness or delaying payments or something. And I saw the ad last night for Ford Motor Company, and it says 6 months free, and then it breaks it down like 3 months deferred, and then they'll pay for it. It looks so good. And so I mentioned it to my husband. He goes, read the small print.
Always read the small print.
Absolutely. Well, that particular windfall there of 6 months free car payment actually applies only if you buy a new car.
Yeah, that's a new car ad. I've seen that spot.
Right. And also you might find in the small print, interest continues to accrue.
Oh, yeah. And as they say, there's no free lunch. There's no,
Well,
I just wanted to throw that out there because when I saw the ad, I thought, wow, that's great. And then no, it wasn't what it seemed.
I appreciate that. And for those of you who are listening on Facebook Live and didn't hear the question, Elizabeth was commenting about an ad she saw from Ford Motor Company regarding loan forgiveness for a period of 6 months. And the fine print had lots of restrictions, like applying only to the purchase of a particular new car. That's really a new car ad, not a loan forgiveness ad. There are companies, including motor vehicle companies and finance companies, who are trying to do the right thing and give some relief to people. Those are legitimate. You must read the fine print. For example, most of them, almost all of them, I guess, are going to say that interest will continue to accrue. Now, that's not unreasonable. They're delaying, the obligation to make principal payments. And, the interest rate, whatever it is, will continue to accrue. It may still be a good deal if you're short on funds. But always read the fine print. Don't assume that because it's in tiny print, You don't need to read it. That's the print you need to read more than anything else. Because if something bad happens and you come to a lawyer, that's the first thing the lawyer is going to read, the fine print. Well, that was like an explosion in my ears.
She's gone. Yep.
Okay, well, thank you, Elizabeth, for your call.
Yeah, good call.
And
good call.
thank you for listening. I appreciate it. I appreciate everybody that listens. So now, can you sue your employer if you miss work and pay as a result of the coronavirus? The short answer is almost universally no. Now, I'm going to tell you folks something, that if you were to call Sadia right now at 781-8003, you would get our voicemail. For the last 2 weeks, we have closed our office down on Fridays because things have become a little bit slower as people are dealing more with the impact of the virus in their own lives and in calling lawyers. And more than that, litigation has slowed down because of the lack of access to the courts. So if somebody calls me, another attorney, and says, can I have a 10-day extension on having to respond to this discovery? And I've given them 3 extensions already. And this would be where I would say, no, I'm filing a motion to compel. Good luck to me. Because by the time that motion is heard, even by telephone, they'll have had their extension. So I might as well just agree. Right now, there's not much you can do about it. I've had some clients very upset about that, and I've had to explain to them, why do you want to pay me to file a motion? They're just going to get their time anyway by the time it gets heard. And so things have slowed, so our office is closed on Fridays. Now, I'm still checking emails, and I'm still checking voicemail, so if you call, it will be heard or seen, and we will try to get back to you either on a Friday or over the weekend or on Monday. But this is a consequence of the current situation. It's one of the reasons people are losing income and some people losing jobs. That's not something I plan to do with my paralegal. But you probably cannot recover from your employer over missed work and pay. Now, I love saying there's exceptions to everything in the law. So where's the exception? If you are one of those employees that has a contract of employment, and if that contract says you're going to be paid $500 a week, and your employer is the one telling you not to come in on Friday, you're entitled to $500 a week. Otherwise, it's a breach of contract.
And she signed a 20-year deal with you. So.
Right. So, I mean, this is something, serious. I mean, if you're a contract employee, you need to look at your contract. And if you're unsure, you need to ask a lawyer and perhaps go in for a consultation or email that contract to a lawyer who's willing to take a quick look at it and see if you might have a claim, for that missed pay or that missed time. A lot of you might. Most of you won't. All right. Now, I was going to talk 2 weeks ago in a very negative fashion about a certain type of advertising I've been seeing. And I unfortunately have, over the course of 2 weeks and the development and expansion of this crisis, sort of modified or modulated my own perspective. I had begun seeing 2 weeks ago lawyers advertising as coronavirus experts. Call us if this, call us if that. Big red letters, coronavirus. And frankly, my reaction to that was it's disgusting, it's unsavory, it's unseemly, and these are ambulance chasers.
Were they that group out of Houston that chases traffic accidents
the one that looks
all
for
the time?
class actions? I don't know.
Yeah, they do.
Look, there were local lawyers that
okay.
were starting to advertise in this way, and I generally am not a fan of TV advertising. I'm not a fan of billboards. I'm one of those staid ones I'm not usually very staid in most things, but I'm one of those staid ones that believe that the lawyer profession is one where maybe you do some print ads and, it's word of mouth more than that. These flashy ads I just don't like. But what has happened over the course of 2 weeks? Obviously, this pandemic has become more serious in the United States. It has impacted more people, both in terms of being exposed to the virus, having caught the virus, being impacted by quarantine orders, even voluntary quarantine orders, as of, I think, midnight this past night, about 10 hours ago, 11 hours ago. Boca Raton is under a mandatory quarantine. That doesn't mean you can't go out of your house, but it has its own executive order, has its own parameters.
And that's where the governor said that
Governor or the mayor.
He would let the mayors
Right.
decide with their own cities.
Right, and so now that has impacted a lot more people in terms of employment. And as I've begun to focus on this and look, well, can we sue under OSHA? What about the ADA? I've looked at some other things. I think I've come across, I'm the first one to come across with this concept of the ADA, but certainly it's not one that's been tested yet. There are some people that have talked about it. I found a hard time finding good articles about it, and I sort of put 2 + 2 together on my own before I was then able to find some articles that at least discussed it in a cursory fashion. I sort of changed my views about the benefits of advertising. Now, I still don't really believe in these flashy ads. It seems to me that sort of takes advantage or seeks to take advantage of the virus and the impact, and I just don't find that seemly.
It's very interesting. We just got a call yesterday afternoon from St. Lucie County, and they have put together an ad asking for the public not to stuff the trash too much for the waste haulers, that the waste haulers need to be safe.
Right.
And this is both recycling and trash. And I think that was a great idea.
And that's a good public service announcement. Excuse me. I heard an ad this morning on my way in asking that you make sure that your garbage cans the lids are fully fastened and tight.
Yep.
And that seems to make sense as well. The sanitation workers, medical healthcare professionals, these are people we don't think about very much, and they are absolutely essential and providing essential services to us and to the country right now.
They're our heroes now.
They really are. We only have a little bit of time, and I'm sort of finished with my advertising thing. I mean, I may do a little bit of advertising myself. It won't be flashy. But, I have this idea, and maybe I can help somebody, and maybe there's the right case to file a lawsuit under the ADA and, see where it goes. But I was in the hospital myself, the ER, on Tuesday night, Wednesday night, was it? Tuesday night. No, Monday night. Now, it wasn't a virus issue, at least not corona, but I had some back pain, and I got a prescription for the back pain from my orthopedic doctor, and I started having all sorts of what we now know were reactions. I was dizzy, I was lightheaded, I had a low-grade fever, which is scary because of the virus.
Those famous side effects.
I was swaying as I walked, and even walking into walls of my home. I felt as if my whole body was like vibrating, if that makes any sense. So I got into my orthopedic because I thought it had to do with my back and my pain. And he says no. My neurologist couldn't see me until the next day, so I called my primary, who got me in immediately. My primary sends me in St. Lucie West next door to the ER. And they run lots of tests. Now, let me tell you something. I'm bringing this up with 3 minutes to go. The clock is running. Because there's an interesting going on in our hospitals these days. You can't get in if you're sick. The world is upside down. I said to my doctor, is it really safe for me to go into the ER right now? And he says it's safer than it's ever been. Sick people can't get in. And sure enough, they had to take my temperature before they let me in the building and give me a green piece of paper that meant I could enter. So I don't know if you're sick where you go, but you don't go to a hospital now. So anyway, I get into the ER. There's a lot more precautions being taken. Everybody's wearing gloves and masks. But everybody was absolutely the best. Caring, compassionate, attentive, answering questions. And I can't say enough about how I was treated. And I got out, didn't stay overnight, got out when all my tests were negative, and the next day the neurologist said, try this, and most of my symptoms are all gone now. So the neurologist had it right. But, look, I was a little bit scared. And they stuck this swab straight up my nose, and I said, is this the corona test? No, this is just the flu test. It's the same thing. Well, that sucker hurt. I let out a little bit of scream, mother, and you can fill in the rest of the word. It's not exactly enjoyable, and I'm a baby to begin with. But in closing, in the minute and a half I guess I got left, stay safe, respect the quarantine, do what you need to do. Essentially, you want to get out and take a drive along the beach. We did. It's a nice way to get out and be safe without impacting and encountering people. Protect yourselves and protect those who are really vulnerable, your parents, your grandparents, and show a little extra appreciation to all those people on the front lines, from healthcare workers to sanitation workers to everybody else who has to expose themselves to protect us. And hopefully we'll all get through this, and as Governor Cuomo says, we'll get through it stronger than ever. That's Ask a Lawyer for today. Take care. I'll be back on Friday and be ready to answer your questions. Have a good weekend and have a good week and be safe.
This is WPSL, Port St. Lucie.